All parties on Cherry versus Keller. Step forward, please.
30-year-old railroad agent Timothy Cherry claims 40-year-old railroad engineer Leroy Keller assaulted him over a parked car that blocked his. Leroy is countersuing for his 30-day job suspension and attorney fees.
Order. All rise. Yeah, this is case number 697 on the calendar in the matter of Cherry versus Keller. Parties have been sworn in, Judge. You may be seated.
You both work for the railroad, is that right?
That's correct.
Yes. And you had this big brouhaha over parked cars. Foolish, right? Foolish. So, Mr. Cherry, why don't you start from the beginning and tell me why you believe Mr. Keller owes you all this money? $3,000 with a counterclaim for another $3,000.
On July the 18th, we have a mail contract to work for the railroad. I was up in the mail car, attending to my duties when Mr. Keller approached me. He was very upset that he couldn't get out from where I was parked.
He couldn't get out?
He couldn't get out of his
parking space because of your car?
Because of where I was parked.
Okay.
Mr. Keller approached me, and his exact words to me were, "Give me your keys, or I'll bust your windows out and ram your car." I turned to the person I was working with at the time, and I told him, well, let me go down and move my car out of his way. As I went to get down out of the car, as soon as I touched the ground, Mr. Keller ran over to me and went to grab me in my chest. I pushed his hands off of me, and I told him not to touch me again and that I would be back. You know, I told the people I was working with I would be back. Let me go and move my car. All the way up the platform over to the garage, Mr. Keller's making shoulder contact with me. He's bumping me, telling me, "Who do you think you are? You have no reason to block me in, and you knew this was my car." I had no idea whose car it was. It was an area where all the employees park. If it happens to where we block each other in, we simply just come and ask to move. Once we got out to the garage, I went to open my door, to let him out. He had went over to his car. Before I could get the key good out of my door, he rushed over to me and pushed me to the side of my car. At that point, I didn't know what he was going to do. He had been to his car. He was back over there. He had pushed me for the second time. I went to my trunk. I actually ran to my trunk, opened my trunk, and removed a baseball bat. By the time I came from the rear of my car, Mr. Keller was on his way back to his car. He started revving his engine. He started moving his car forward like he was going to ram my car. And by the time I backed up enough for him to get out, he actually did make contact, but it didn't cause any damage at that point. He left the garage. I immediately picked up the phone and called 911. As I'm on the phone with the 911 operator, Mr. Keller enters the garage again from the other direction. He gets out of his car and approaches me, reaching for my phone. I have pictures of the damage that was done to my car.
Well, I thought you said there was no damage done to your car.
The damage that happened to my car was a result of him shoving me to the side. When he shoved me to the side, it was this elbow, I guess, that caused the damage.
When did he shove you to the side?
When I went to take my key out of my lock, he came rushing over to me at my car and pushed me to the side. He got inside of my car, released my emergency brake, and started pushing my car backwards.
Let me see the alleged damage to your car, sir.
Sure. Those are pictures. I have a light-colored car. It's kind of hard to see it, but I tried to take it from an angle where you could see the indentures.
It's very hard to see.
I also have an estimate, Judge, where
Let me see it.
That particular place was estimated.
Although I'm having difficulty seeing it, clearly the place where you took your car in to be repaired from where you claim that he came over and pushed you, you have a bill for $526.42. Okay, Mr. Keller.
Judge, I would like to show a diagram of the parking lot in the car incident. This shows the train as which this was where Mr. Cherry was located working on the train. I came into work that morning about 7:30 a.m. after being on duty for 14 straight hours with nothing to eat. I went from this location here to my car, which was parked here, and as you can see, Mr. Cherry's car has me pinned in between a concrete wall and two other cars. I walked from this location through this door to the ticket window, and I asked the ticket agent, I said, there's a Mazda 626 parked out here, and I gave him the license plate number. I said, could you make an announcement? I thought maybe there was a passenger waiting to pick up someone that had just parked there and would be there for temporary time. The ticket agent, he said, I know whose car that is. That's Mr. Cherry. He works here. I said, well, could you get a hold of him and have him move the car? I'd like to go home. He went outside to look, and he said Mr. Cherry was way down at the end of the platform here working on the train. I said, okay. I said, I'm going to call the parking lot and find out if there is a policy of double parking here.
But there are a lot of other cars that are double parked.
There was one other car double parked.
Well, I see that. So what did you do, sir?
So I went in and I talked to the security. They said it was a matter that they couldn't handle. So then they suggested calling the police and calling the tow truck. And the tow truck said that he could not tow a car unless he had permission from the police, and the car had to be parked there for 48 hours.
Okay. First you found out the car belonged to Mr. Cherry. So how long did that take? How many minutes?
Probably about 10 minutes.
Okay. And then you were still at that location when you called the tow truck?
Yes.
A tow truck. Did you have to get a number of a tow truck?
Yes, out of the yellow pages.
Okay, so you had to get the yellow pages, look up a tow truck, and call a tow truck. And about how long did that take?
Another 5 minutes.
So that's 15 minutes. Did you call the police?
I spoke to the dispatcher, and they said that there was nothing they could do.
That took another 10 minutes?
No.
How
just
long?
A couple minutes.
Another 5 minutes?
Yeah.
Okay. So now we're up to about 20 minutes.
Yes.
Right. And then you decided yourself to walk over to where Mr. Cherry was working.
Yes.
And how long, sir, did it take you to get from the ticket window where you were over to where Mr. Cherry was?
About 3 or 4 minutes.
Judge Judy continues in a moment.
I said, are you crazy? I said, do you realize what you're doing here? He says, look, you're lucky I don't get my gun out of my trunk and kill you.
Real cases, real people. Judge Judy. Railroad agent Timothy Cherry is suing railroad engineer Leroy Keller for assault after Timothy blocked his car.
So my first question to you is, sir, instead of calling a tow truck, which took 10 minutes, calling the police, which took another 5 minutes, 15 minutes, why didn't you just take a 3-minute walk over to where he was and say, why don't you move your car?
Mr. Cherry and I have had an interaction before.
What kind of an interaction did you have before?
One evening about 11:30 p.m., I was on my way to work and I was coming into the parking lot. There is a stop sign that's displayed because there's a bad intersection. I stopped at the stop sign. Mr. Cherry drove around me at a high rate of speed to get to his parking spot. And I said to him, I said, did you know there was a stop sign back there? And he said, I'm from St. Louis. We don't stop at stop signs.
So, what did you say?
With that attitude, I figured there's no sense talking to a gentleman.
So you didn't
like
say anything to him?
No, I didn't.
No, okay. So then you walked over there.
Yes.
What happened when you got over to him?
When I got over to him, I said, do you own a Mazda 626? He said, yes. I said, well, you're blocking me. I said, I'd like for you to move the car.
Is that the way you said it, sir?
Yes.
You sure about that?
Yes. He said, I'll move it when I get done with my work.
Or middle?
And I said to him, I said, I have been delayed long enough. I would like to go home. I've been up for 14 hours, and I would like to go home. He said, I'll take care of it when I get done with my work. Once again, I suggested to him, I said, just give me your keys, I'll move your car for you, and I'll leave the keys at the ticket window. He threw his gloves down, and he started getting upset, cussing at me, and telling me that he wasn't going to give me his MF keys. He jumped out of this train car, and instead of climbing down the ladder, he tried to jump on top of me. And with my natural reactions of him coming out on top of me, I pushed to keep him away from me. Once he got down on the platform, then he started chest butting me around. And I told him, I said, look, I said, I don't have time for this. I want to go home. So we walked from the train back through the depot. I went through the first door in the depot from the train station, through this door and to my car. Mr. Cherry went back into the baggage room through the employee's room, and he stayed back there another 5 minutes before he came out of there. I sat in my car waiting for him. When he finally showed up, when he come through this door and he came out here, instead of getting directly in his car and initiating the move directly, he stood by his car with his arms folded and just grinned at me. So when he came over to his car, he put his keys in his door, unlocked his door, opened up his door, got into his car, sat in his car, and looked at me again. Then he got out of his car, and he went to the trunk. So I went over to look. I looked inside the car. I noticed it was a manual shift car. I popped it in neutral, and I put my shoulder on the doorpost and give it a push back. As I was pushing the car back with my door on the doorpost, when I looked up, Mr. Cherry has a baseball bat, and he was taking a swing at me. I said, "Are you crazy?" I said, "Do you realize what you're doing here?" He says, "Look, you're lucky I don't get my gun out of my trunk and kill you." And I said, "That's it."
Hey.
I said, "That's it." I got in my car. By that time, I had pushed it back myself. I got in my car. As I was leaving, I looked in my rearview mirror, and yes, he did have his cell phone out, and I figured, he's calling the police. I'm going to be in trouble if I leave the location. I pick up my cell phone in my car. I call the police. The dispatcher says, "Yeah, we have an altercation down at the Amtrak station." I said, "I think I'm involved in that." I said, "Would you like me to return to the location?" "Yes, that would probably be the best thing to do." So I returned to the location. After talking to the police, they tried to resolve the situation, and they talked to us, and they explained to us that either one of us would file charges against each other. We're going to end up in jail that day. The officer told me, he said, "If you go up to him and you just shake his hand and apologize to him and say, 'Let's forget this,' we'll let it go." So I went up to him and I extended my hand, I shook my hand, and the officer said, "Go on, we'll take care of it." So a few days later, about 3 days later, my supervisor calls me and he asked me about this situation. The company decides to hold a formal investigation. Through the formal investigation, the facts were gathered that both of us were at fault.
Responsible.
That's correct.
And they docked you both a month's pay?
They fired us both for 30 days.
Okay. That's your cross complaint. You want the amount of money that you lost for being fired for 30 days. That's what you say here.
What I'm having a problem with is, after 30 days of being disciplined, Mr. Cherry files an assault report with the police. I have to go hire an attorney to represent me in this case. It cost me $700. The prosecuting attorney dropped the case due to lack of evidence on the police report. That wasn't good enough for Mr. Cherry. Now Mr. Cherry is filing a claim against me in small claims court. I feel that, if anything, I'm entitled to the lawyer's fees that I've had to pay for purely out of harassment on Mr. Cherry's part of trying to get even with me.
Judge Judy continues in a moment.
He actually had his hands firmly put on my chest, Judge,
All right,
and I
Mr.
removed
Cherry,
them off of
you're
it.
not a wimp, are you? You're not a wimp. You weren't injured. He overreacted.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Railroad agent Timothy Cherry is suing railroad engineer Leroy Keller for assault. Leroy is countersuing for lost wages and attorney fees that resulted from the fight.
Let me tell you, I've heard your side of the story, and I've heard your side of the story. Each of the stories flavored and colored a little bit to suit your own purposes. So let me tell you what I think happened. I think as far as the parking and blocking his car is concerned, Mr. Cherry, that was absolutely the wrong thing to do. You never know if you block somebody's car, whether it's 5 minutes, 10 minutes, or an hour, or 2 hours, that say nothing. That there may be an emergency, somebody has to get their car out right away, and it's very irritating, especially when you're at some distance from where you have inconvenienced somebody. So I don't blame him for getting angry. Now, the fact that you had a history before suggests to me, Mr. Keller, that you were not as calm as you present yourself here today. I do not believe that after you spent 15 to 20 minutes trying to get even with him by having his car towed away by the police rather than walking 3 minutes over to where he was working to tell him to move his car, that you were happy with him, that you walked up to him and said, "Could you please move your car? I'd like to get out." That is inconsistent with human nature, and it's inconsistent with male testosterone. It just doesn't happen that way, Mr. Keller. So that he doesn't know what's happening, all of a sudden you come up, you've had a little tiff before, and you start screaming at him to move his car, and probably used a couple of expletives in the process. Then Mr. Cherry gets irritated, and he's going to take a walk back to help you move your car, but he's going to take his sweet time about doing it. So he's sitting in the car, burning and stewing. Now, I absolutely think that he was 100% wrong to go into your car and move it physically. Now, what I want to know from you, Mr. Cherry, is once this was all over, sir, and you had your disciplinary proceeding, and you all went through getting laid off for a month and lost wages over this nonsense, why did you file assault charges against him?
By him grabbing me in my chest, he made threats not only to me, but to my vehicle. When I got to my vehicle, Mr. Keller continued with his threats.
It's a little overreacting, Mr. Cherry.
He actually had his hands firmly put on my chest, Judge,
All right,
and I
Mr.
removed
Cherry,
them off of him.
you're not a wimp, are you? You're not a wimp. You weren't injured. He overreacted.
I have
He
sworn testimonies, Your Honor.
overreacted, sir. He overreacted. You know, I'm not going to give him an award or a testimonial dinner for his loud mouth, for his bad attitude, for doing the wrong thing, I think, judgment-wise, about your car. But there comes a point where you have to put a period and say, all right, this is enough. We both suffered from this incident. It was the wrong thing.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Mr. Keller, I believe, sir, that you overreacted to this situation. You got good and mad. I can imagine that you've seen people in a parking lot waiting to get their car out for 3 minutes, and they get crazy if they want to get out of a parking spot and somebody is blocking them. So, Mr. Cherry, I am giving you the money to fix your car. I think that you both got hot under the collar. Both of you. However, you had out of pocket that you can establish to me to fix your car, and I assume that you're fixing your car, sir? $526. As far as your counterclaim is concerned, Mr. Keller, I believe that in this instance, if I were to indicate that one person was the aggressor, in this case, it would be you. He may have known how to push your buttons, but once your button is pushed, that's your responsibility. And you did certain things that I could tell that somebody who was only very, very angry would do. Take control over somebody else's vehicle because they're not moving fast enough to push it away manually is something that somebody would only do if their testosterone level was up to their eyes. So judgment for the plaintiff in the amount of $526. The counterclaim is dismissed. That's all.
Parties are excused. You may step out.
Judge Judy continues in a moment.
Parties on Taylor versus Sadlaka. Step forward, please.
38-year-old attorney Suzanne Taylor is suing 45-year-old property manager Peter Sadlaka for fees for an eviction case. He's countersuing for the loss of his building.
Order. All rise. Quiet, please. Yeah, this is case number 665 on the calendar in the matter of Taylor versus Sadlaka. Parties have been sworn in, Judge. You may be seated.
Ms. Taylor, you're an attorney.
Yes, Your Honor.
This is a suit against a former client of yours for non-payment of a legal fee that had been part of a retainer agreement. Is that right?
That's correct, yes.
Can I see the retainer agreement, please?
It's a retainer with the signature.
All right, so you signed this retainer agreement?
Yes, ma'am.
And for what period of time did you represent the defendant?
I represented him from March 10th of '98 was our first meeting, and on August 7th, I told him I would not represent him anymore.
What kind of proceeding was this?
It was a commercial eviction. He's the owner of property. There's a bar on the premises, and he was trying to evict the tenant.
Why did you tell him that you would no longer represent him?
Mr. Sudluka was very difficult to represent. The first action we brought, when he came to my office, he already had an action underway, and he had gone to court and said that no rent had been paid, when in fact the rent had been paid to his lawyer prior to the court date.
So he had a prior lawyer?
Yes.
Is that correct, sir?
Yes, ma'am.
Go ahead.
After that, I served a notice. I reviewed his documents regarding the lease and the documents that he gave me, and I served a notice on his tenant noting all the violations of the terms of the lease, and after 20 days we were to bring an eviction action. By the time we got to court, he had accepted rent, which after you terminate a tenancy, accepting rent begins a new tenancy. So again, we had to go and apologize to the judge and say that we could not go forward with the proceeding.
Did you explain to him that he couldn't accept rent?
I explained to him when he told me he had received an accepted rent, but he didn't ask me at the time he received it what he should do. Instead, he asked a friend of his, and his friend gave him the advice to accept the rent.
Now, when did you find out that he had had a prior lawyer who accepted rent for him?
When he came into my office on March 10th.
How many lawyers have you had in the last 2 years?
Ms. Taylor and my first lawyer.
Are you telling me that in the last 2 years, with regards to any action that you have had on this property, you only had 2 lawyers?
That's correct.
All right, when did you buy this property?
I sold it in August of '94
You sold it to whom?
to my tenants.
You sold it in 1994. What were you suing them for rent for in 98?
They breached the contract, and I wanted to evict them. And I actually got an eviction granted on March 4th. The judge says, eviction granted. Then they came up with a show cause order for me. Well, I had all the goods on them. I said, let's go. Well, the second time around, I said, well, maybe I ought to take a lawyer on and go and see the judge the second time around, because all I got is a formality here. On March 16th, after confiding in Ms. Taylor, we went to court. And we stood there like we are right now. I'm in a situation with all this evidence in front of me. My tenant's landlord and Ms. Taylor walk up to the judge. They did a little bit of whispering, et cetera, et cetera, et cetera. And then she walked back out of me and says, we have to leave now. This confused me a lot, because I just wanted to be heard and have the judge decide what the problem.
Had you accepted rent just prior to your going into court on that occasion with Ms. Taylor?
No.
Are you telling me, sir, that from the time you went into Ms. Taylor's office, when you first retained her, to the time you appeared before the judge that you've just described to me, you accepted no rent from the tenant?
No, but what
Who did?
I did on March 4th, not on March 16th.
No, listen to me carefully.
Yes.
So the answer to my question is, on March 4th, you accepted rent from your tenant.
Correct.
Just listen.
Yes.
And on March 16th, you went to court with Ms. Taylor. Is that right?
That is correct.
When you accepted the rent on March 4th from your tenant, did you consult Ms. Taylor prior to you accepting the rent?
I didn't know her then.
Your Honor, he did have another attorney at that time.
Did you consult your other attorney?
No, because he didn't. He wrote me a letter that said that he was dropping my case after not taking care of the business at hand.
Just a second.
Okay.
Did you, prior to March 16th, notify Ms. Taylor that you had accepted rent?
Yes.
When?
When I saw her. I don't remember what date we sat down and talked, but I did tell her this.
Ms. Taylor, did he ever tell you prior to you going to court that he accepted rent?
He told me after he'd already gone in front of the judge on his own and asked for an eviction based on non-payment, and we went in on the 16th to sort of make reparations and apologize to the judge.
That you could not go forward.
That's correct.
You owe her money. Period. End of discussion.
Well, that might
You
be
owe
so,
her
Your
money.
Honor. But that might be so. But there still is the fact that I was breached 6 different times, and all I wanted to do is have the judge look at the situation as it existed and cast a judgment on the contract that I had that said they should have been evicted by the contract that was written, not what could have happened.
Mr. Sidlaka, let me tell you something. There are a lot of lawyers in the United States of America. I know a lot of lawyers who practice. There are very, very few lawyers that tell a client to go take a hike, that we don't want to represent you anymore. Lawyers are used to dealing with difficult clients.
Judge Judy continues in a moment.
So if you don't like what the judge did, file a complaint. They'll take your complaint, they'll throw it in the garbage.
And later today,
Madam, this is a court. Courts deal with contracts, verbal contracts or written contracts, not what you feel.
real cases, real people. Judge Judy. Attorney Suzanne Taylor is suing property manager Peter Sedlaka for her fees for an eviction case.
What I'm hearing today is that your first lawyer discharged you as a client. That's what you told me.
Yes.
And your second lawyer discharged you as a client.
Yes.
I can understand why. You owe her the money. Now, she sent you a bill for $1,000. You have an item, you have an accounting form?
I have the invoice that I sent on August
Let me
7th when I
see it.
discharged him. Since then, it's been interest and collection costs, which are under the retainer agreement.
You received this?
Well, yes, I did.
Good. Did you ever, in writing, question any of the charges here?
From Ms. Taylor?
Yes.
No.
Good.
But I definitely did question the judge not speaking to me. This whole thing could have been settled. When I stood in front of the judge, he said, look, you don't have enough here, even though you got 5 different counts on these people for eviction. Sorry, you can't do it. We stood in front of that judge and we walked out that day. I was not satisfied.
Well, whether you're satisfied or not, that has nothing to do with your paying her.
Oh, I
Judge,
don't mind paying her.
Good!
But that does not negate the fact that I was not I had no due process of law in the
Write a
courtroom
letter to
itself.
Dear Abby, sir. Let me tell you something. Judges don't necessarily hear litigants individually when they're represented by counsel. When I have an attorney before me who's representing somebody and the client opens their mouth and wants to speak, I say to them, sir or madam, you have the following choices. Either you discharge your attorney, in such case you are appearing pro se and I will listen to you. Otherwise, whatever you have to say to me, you say to me through your lawyer.
True.
So if you don't like what the judge did, file a complaint. They'll take your complaint and they'll throw it in the garbage. This lady you're going to pay. And this nonsense counterclaim that because of her mishandling of your case, you lost your building, is
that's
nonsense.
True. But it isn't nonsense, sir.
Of course
ma'am.
it is.
Well, then none of this.
Of course it is.
None of these breaches count then. All these
Just
breaches.
a second.
Yes.
You had 2 lawyers. 2.
True. I'm not. Look, the lawyers. If the judge had just told me
This
that.
has nothing to do with the judge. The judge is not trial here,
No,
sir.
he is. No, he isn't.
That's
but had he
right.
just listened to the breaches that were concerned here, he could have seen that these people should have been gone.
Shoulda, woulda, coulda. He didn't want to hear him that day because you had accepted rent. And once you accept rent, the eviction
I
proceeding
only
is over. Judgment for the plaintiff in the amount of $1,000. That's all.
Parties are excused. You may
Thank you,
step
Your
out.
Honor.
All right, no problem.
The fact of the matter is that he sold the building, and he regretted that later, and he was trying to find a way to undo it.
They tell me now that because it's all past the water under the bridge, I can't do it any longer. Only one shot at the brass ring, right?
And now the next case.
Parties on Medeiros versus Roden. Step forward, please.
Bowling League member Julie Medeiros says substitute bowler Wayman Roden owes her half the money won in a Las Vegas tournament. Wayman claims they had no agreement to split the winnings.
You 2 folks are in a bowling league. Is that right?
Yes.
According to your complaint, there is a tournament, a big tournament held in Las Vegas. Mm-hmm. And for personal reasons, you were unable to go. Is that right?
Considering not going, yes.
You were unable to go. the defendant went in your place, you said you had an agreement with him that should the team win, you would receive half of the winnings.
I made an agreement that no matter what the team wins, I get half of the winnings.
Fine. Team won. He refused to give you half the winnings.
True.
Okay. And your defense is what, sir?
Basically what she said, except that I didn't agree to give her half of anything. I agreed to share the winnings with her. But
That's
she's
what you
claiming that everything that I received is winnings, and even the IRS will let you deduct your out-of-pocket expenses before they ask for their share.
So what your defense is that you did agree to share the winnings with her.
Right.
But that you had certain out-of-pocket expenses, and some of your out-of-pocket expenses were what you put into the league.
Right.
How much exactly did each team member win?
We received $550 each.
What you say you should be getting $225.
550, I should be getting,
Why?
pardon
Yeah,
me?
why?
Well, just a second. Now, my question to you is, why, if the team won $550, you don't dispute that,
No.
and given the best case scenario for you, that he agreed to give you half the winnings, that's $225. So I don't understand why you are suing him for $525.
Yeah, I'm suing him for $525 because everyone puts into the league throughout the year. And at the end of the season, each person puts in $250 towards their trip there.
Right.
Okay, so I'm out of pocket there, $250.
But he didn't agree to give you that.
No, he didn't. And the
Well,
only
just a
reason that
second.
I asked for it
Yeah.
was because he then didn't agree to give me what we had verbally agreed upon. So I also asked for the $250, what I was out of pocket. Letting
But there was
him
no
go,
agreement. But just a
letting
second,
him
but
go
there
in my
was-
place.
I'm speaking. Madam, this is a court. Courts deal with contracts, verbal contracts or written contracts. Not what you feel, but verbal or written contracts. You had no agreement with him if he went in your place to cover what you had put into the league up until the time of the tournament.
That was not our agreement, no.
It's not your agreement, so you
No.
can't sue on it. What are you suing on?
That's what I was asking for.
Well, I just want you to understand
Right.
why I would not consider it, because it's foolishness. It's what a court is. Court deals with contracts. So it's $275.
Judge Judy continues in a moment.
You got a bargain, Mr. Roten. For your $120. For your $120, you got 2 nights stay, and you got 2 meals a day, including 2 banquets. So don't give me nonsense about your $120 when you contributed half of what everybody but 2 people did to go to the league.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Bowling League member Julie Medeiros is suing substitute bowler Wayman Roden for half the money won in a Las Vegas tournament.
Now, why shouldn't I give her $275?
Because I didn't win $550.
What did you win?
I won $171.
How did you win $171?
I received $550, but I had out-of-pocket expense.
What out-of-pocket expense?
I paid $128 into the league.
Just a minute. Well, so did she. So what? The $128 into the league, sir, listen to me. According to her, each person contributes so much towards going to the tournament.
Right.
Is that right?
Right.
And that's what your $120 was. Right? Going towards going.
It goes into
Listen
the
to me.
prize fund.
Whatever it is. She contributed $250. Put your hand down. She contributed $250. You
Right.
contributed $120. Did you have to contribute any more than the $120?
I didn't have to.
Good. So that she contributed $250, and based at least in part on the fact that she contributed the $250, you were able to go. Is that right?
No.
Yes, sir.
Yeah. Listen to me. Listen to me. Does every team member, pay attention, does every team member contribute $250
No.
for the privilege of going through the course of the year.
No.
They contribute different amounts?
Yes.
Based on what?
You pay a certain amount each week that you bowl.
Right, but that has to, are you telling me, Mr. Roden, that every member of the league contributes different amounts?
Okay, I subbed for 3 different people, and I paid into the league during that time. I asked the secretary, how many games do I have to bowl to be eligible to go? She said, you have to bowl 45 games.
Just a second. Are you from the league? Is that
Yes.
you look like you have something to say? Step up here, please. I just have a few questions for you. Tell me your name.
My name's Robin Sloan.
Miss Sloan, how many people are there in this league?
56.
And do you take care of the finances for
Yes.
this? How many people actually go to Las Vegas from your league for the tournament?
56.
And what amount does everybody put into this general fund in order to go?
$250.
No.
Per person.
No way.
Raymond was a sub in the league. He's
Yes.
an alternate.
Right.
So he didn't have a guaranteed spot to go. He was just trying to get enough games in to be eligible to go. He didn't pay $250 into the league, but Julie did, and so did all the other 55 bowlers.
Okay. Now, was he the only sub?
No.
There were other subs. How many?
Yes.
One other.
And how much money did he get?
I
Talk-
didn't have arrangement with Cecil, sorry.
Mr. Roden,
Yes.
you're wrong, sir. You're wrong. Now, this $250, what does it go for?
It goes for the hotel, food, and their tournament expense.
Okay. So the hotel, and how many days do you stay at the hotel?
2 nights and 3 days.
Okay. Do you share a room with someone?
Yes, it's double occupancy.
Okay, and it pays for a meal allowance?
You get 2 meals, 2 dinner banquets, and then you have 2 brunches.
Okay, and that's what this $250 is for?
Right.
Is that right?
Yes.
You got a bargain, Mr. Roden. Okay, for your $120. For your $120, you got 2 nights stay, and you got 2 meals a day, including 2 banquets. So don't give me nonsense about your $120 when you contributed half of what everybody but 2 people did to go to the league. So what other out-of-pocket expenses did you have?
To get there and back. It's 1,100 miles from my house to Las Vegas.
So who dragged you?
No one.
Good. You didn't have an arrangement with her when you said to her, I'll share the expenses with you. You didn't say, I'll share the expenses with you and deduct from the expenses that I will share with you my gas and wear and tear on my
I didn't tell her a
car.
percentage of anything either. Not 50% or not 1%. I just said I would share
Well, then,
and do what
Share
was
and
just a
right.
second. Shh. Are you speaking out?
No.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Well, Mr. Roden, then, based upon what she says, you said you would give her half. Based upon what you say, you will share the winnings with her. So that, let us assume that I believe you. Then that leaves up to the court, not to you, what I believe is fair.
That's right.
Good. And I believe that anything other than a 50% split would be arbitrary, because I could say it could be 40%, it could be 33%. That would be arbitrary of me. Right? If I were to say to you, Mr. Roden, what do you think a fair allocation is, then you would say 30% or 25%, and you would be rewriting this agreement. So somebody has to rewrite the agreement, because you did, according to you, have an agreement to share.
That's correct.
I believe share means 50%. Judgment for the plaintiff, $275. That's all.
Parties are excused. You may step out.
Judge Judy continues.
All parties on Patterson versus Robinson. Step forward, please.
27-year-old child support officer Merica Patterson is suing 22-year-old Annette Robinson and her husband Richard Scott, 40, for scratching her car as Merica picked up her child.
Order. All rise. Your Honor, this is case number 642 on the calendar in the matter of Patterson versus Robinson. Parties have been sworn in, Judge. You may be seated.
Who are you?
The plaintiff.
Well, you're the plaintiff because the car that was allegedly damaged was your car, is that right?
Yes.
But you don't know anything about this. You weren't there.
I wasn't there when
So why don't you have a seat?
Okay.
Miss Patterson, this gentleman is your former husband, is that correct?
That's correct.
How long have you been divorced?
Since '96.
And you have one child together?
Correct.
How old is that child?
My son is 4.
And you are his present fiancé.
Yes.
Well, in this unfortunate situation, the basics of it are that you went to pick up your son from a period of visitation at their house.
That's correct.
And there was an altercation between you and Miss Robinson. You claim that during that altercation, she damaged your car. Is that right?
That's correct.
Okay. So Sunday at 8 o'clock, you arrived to pick him up, and what happened?
Instead of my son coming down, Annette came down and she...
This is Annette.
Correct. And she came to my car and she had my son's boot with her. And I asked where my son was, and she says, I want to talk to you first. And she laid across my car like this, holding the boot, and she kept telling me that I was going to talk to her. I was not going to get my son until I talked to her. She would give me this boot back now and give me back the other one when she received Drew's Nikes back. And
Drew's Nikes, you mean his sneakers?
Correct. And I just didn't want to go through all this. I just wanted to get my child and leave. They have a locked door on their apartment, so I can't, like, I have to sit down there and wait for them to bring my child out. And instead of my child being down there, she came down.
So your complaint says that she scratched the roof of your car with this boot.
Correct.
Let me see the damage to your car. So there's a long scratch on the car.
Correct.
One scratch, is that right? Okay. Miss Robinson, would you mind telling me what you were doing coming down to talk to her?
Mrs. Patterson has made an issue about all the clothing that Andrew wears. So what I did is I just simply went down there to talk to her. She had accused me of giving away Andrew's shoes to their child.
When did she accuse you of giving away his clothes?
Earlier that week. She had called me and asked me where his other shoe was, and I said I'm looking for it. He threw it when he was taking off his shoes and get ready for a bath. So I told him I was still looking for his other shoe, and just give me a minute, or just give me some time and I'll find the other one.
What else was there in the conversation?
That was it.
Well, that she didn't accuse you of giving away his clothes.
She asked me, well, I think you gave it away to Nellie, which is another little girl Andrew currently plays with and talks a lot about.
Did you ever say that to her?
No, the only reason that got brought up, I asked her about it, is because my son came home saying that Nellie wore his shoes home. So I asked her about that.
So the mother comes to pick up the child after a period of visitation, and you go down there with one shoe. Now, what was the purpose of going down there with the one shoe?
Letting her know that the other one was lost. I was very genuine about letting her know. I'm very serious.
The other one of this was a pair?
Yeah.
So why didn't you just come downstairs, or why didn't you go downstairs with your son to keep this very calm?
Well, for one thing, I didn't want to get Drew in the middle of an argument because
It wouldn't have been an argument.
She makes an issue out of everything, Your Honor. Everything, and I try to keep Andrew out of it. So
good. Then she should have kept Andrew out of it, and you go downstairs and talk to your ex-wife. I mean, had you been friendly with each other before this incident?
No.
Listen, tell me about the shoe. I don't see how this shoe could have caused the scratches to your car, madam. I really don't.
Okay, I don't know if the shoe does have the eyelets on it and stuff, but I don't know if maybe there was a rock in the bottom of the shoe at the time, or the fact that she does have a big, bulky watch that she wears, and that she was laying across my car like this. So not that it's just that the fact that she did have the shoe in her hand, and that's what was of her body was touching the car, was her arms and the shoe. And she was waving her arms across the top of the car and pounding the shoe on top of my car, telling me that I was not going to get my son until I discussed this issue with her.
Look, there was a big problem about clothes, because I read your answer very carefully.
Mm-hmm.
I read it, and I didn't like it. I didn't like it because originally, according to your answer, you were going to drop off little boy at his mother's house. Is that right? Mm-hmm. On that day? Wasn't that your plan?
That's what started, yes.
And then you decided not to do it because of this clothes problem. That's what it says here. Mm-hmm. Right?
Mm-hmm.
We had second thoughts about returning Andrew directly to their house, though, because he was wearing clothes Rick and I bought. Marcia had made a big issue about these clothes often failing to return to us, the ones that we sent. So we decided it would be best to send Andrew home in the clothes that his mother sent him over in. So that means that this little 4-year-old boy comes back from wherever you had him out for the day, and you say you have to get out of those clothes. You have to put on your mommy clothes. These are your daddy clothes. You got to put on your mommy clothes. Is that what you're telling me? Come on. What you're doing by saying that to him is, this is not a nice thing between my mother and my father. They make me change my shoes and my socks and my underwear and my clothes in order to go back to my mother. Don't you see that there's something wrong with that?
Yes, I do.
So why do you do it?
This has been going on for a while. We've been sending them over in clothes and never said anything. We've not gotten any of the clothes back. Or when she sends them back over, they're not even in half the clothes we even sent over. I've never seen them again.
Let me ask you this question, sir. Does she have another 4-year-old child in her house?
No.
So whatever clothes you buy for your son, he's wearing.
Right.
He may be wearing them to school. He may be wearing them out to play. Now, he also, I'm going to ask you one other question. He doesn't come to your house for the start of visitation naked, right?
No, he comes in clothes that are almost 2 sizes too small for him. I mean, I can't even take him to the store after I pick him up. I have to take him home and change him first.
He doesn't come to your house naked.
No, he doesn't.
Okay. So what difference does it make?
Judge Judy will continue in a moment.
Annette, butt out.
And later today,
Now, you got some heck of a nerve to give her $15 Christmas time on a $3,000 debt.
real cases, real people. Judge Judy. Marika Patterson claims her former husband's fiancée, Annette Robinson, scratched her car when she picked up her child.
You see, just so that you'll recognize this, first wives and second wives don't get along. That's just the way it is. They could be both lovely people. It's the rare case where the first wife and the second wife get along, and the only time that that usually happens is when they both hate the husband. That's just the way life is. So you don't send your fiancé down to do your bidding, because it's just dumb and counterproductive.
I didn't send her down, Your Honor. She made that choice to go down.
Well, that was ridiculous. And it shouldn't happen again. Because if you return Andrew to his mother when she's been agitated by something that your fiancé does, who do you think's going to suffer? You're supposed to try to alleviate whatever stressors you can. This is a stressor. Now, you may not be able to alleviate the stressors that exist between the two of you, although that's really dumb, because if he wasn't a great guy for you, he may be a great guy for this lady, but he wasn't great for you. You have a nice new husband? You happy?
Yeah.
Terrific! He's going to have a nice new wife. He's going to be happy. Terrific. You happen to have a child together that's going to tie you together for the next 30 years probably, or more. So you try to get along.
We didn't have any problems for a long time until she came along and started trying to maneuver and instigate and make decisions and do things. We really didn't have a problem between the both of us.
The main reason that Annette kind of took over on some of the things is because whenever I would take Andrew down with me, she would chew on me right in front of Andrew.
That is unacceptable. Listen to me. When the child is there, nobody is to say anything negative or that would precipitate an argument. Hello, how are you? Did you have a nice time? Thank you very much. I'd like to speak to you. Give me a buzz later in the house. Period. And when you take the call, take it and make sure that Andrew isn't around. Both of you. It's as simple as that. You should have absolutely no reason to have any negative conversation with him.
When I go to pick him up, I don't talk to them at all. I just take my son and leave. It's when she comes down to the car and my child's not there, I don't have a choice. I don't wish to speak to them.
Has this happened before?
With Annette coming down to my car, yes, this happened 2 other times that she came down to my car and they held my son in the apartment.
For what reason?
So I would talk to her about whatever issues they felt were issues at the time.
Annette, butt out. It's none of your business. Zero. You have no business getting yourself involved and injecting yourself into their life. Absolutely none. Listen to me. Don't be a wimp. Don't send her down to do your work. To send this lady, seems like a nice lady, down to do your job, understanding the premise that I started with today was first wives and second wives usually don't get along, is a very foolish thing to do and not good for your son. And certainly not over clothes. It's not such a big deal. I mean, I don't know whether you send him over in clothes that are not of good quality. If you're doing it to be a little spiteful and to give him a dig, don't do it because it's hurtful to your child. But they're his clothes. They're not your clothes. They're not her clothes. They're his clothes, and he's wearing them. Stop making a big deal about it. This is nonsense. Hey, Miss Patterson, you have another child now. You have a daughter, right? I assume that you would scratch the eyes out of any person who tried to emotionally harm either of your 2 children. Is that right?
That's correct.
And that's the way you should feel as well. When he hears either parent talking badly about the other, even when you're talking to his father on the phone, that does not make him feel good. If you're doing it, stop. That's all.
Parties are excused. You may step out.
America is just jealous of Annette more than anything is what I think it is. She thinks that she's, jealous that maybe Andrew might like her more or something. I'm not sure exactly what it is.
The truth of it being is we take very good care of that child. He don't pay child support. He's over 3 years back behind child support.
And now the next case.
All parties on Bates versus Barkdale. Step forward, please.
Retiree Alga Bates claims 40-year-old waitress Sharon Barkdale owes her over $3,000. Sharon claims Alga is trying to ruin her life.
Miss Bates, according to your complaint, the defendant was a neighbor of yours and became a friend. Is that right?
Yes, Your Honor.
And according to your complaint, she told you that she had some financial problems.
Yes, Your Honor.
And that you loaned her, in a series of loans, $3,025. Is that right?
No, Your Honor. We loaned her $3,840, and she paid back $815, which left a balance still to be paid of $3,025.
Thank you. Okay, now, Miss Barkdale, you acknowledge in your answer to her complaint that you borrowed this money.
Yes.
And you say, however, that after you borrowed the money, she became controlling of your life, caused you a lot of stress. Therefore, you are not going to pay her a penny. And in addition, you're countersuing for $5,000 for nuisance, harassment, pain, and suffering. So, Miss Bates, you don't have to say anything. She's acknowledged that she borrowed the money. She's acknowledged that the outstanding amount is $3,025. Is that right?
That's correct.
Judge Judy will continue in a moment.
How dare you have a Christmas party when you still owe her $3,000? You got some heck of a nerve. I mean, if you're a big girl and you don't want somebody to act like your mother, start growing up.
Closed captioning sponsored in part by Real Cases, Real People, Judge Judy. Alga Bates is suing Sharon Barkdale for the return of over $3,000 in loans.
Okay, now, Miss Barkdale, convince me.
All right. In December, Olga and I were very good friends, and at that time she had become controlling of my life. She was like a mother figure to me. I felt very close to her, but the more that I felt close to her, the more controlling she became over me. So at that point, I severed the relationship. I felt like she wanted to sever the relationship, and I was still paying her small amounts of money until one day I went to work and she left a message on my machine saying that if I didn't pay her more money, that she was going to have me fired from the Hyatt, or go to the Hyatt, excuse me, not fired, go to the Hyatt and tell my employer that I owed her this money. So I wrote her a letter saying, please don't do that, because if you do that, it's going to cause these problems. Number one, they don't want to hear personal problems. Number two, if you do that, I'll get fired and I won't have a job to pay you back. And number three, here's $15 intent to pay, and let's work through this. So after that happened, I had a Christmas tree in my house, and I had sent out some invitations for a party. I left a cocktail notice on one of the neighbors upstairs, and she went and got it off his door and called him in LA and told him that I was having a cocktail party. She then leaves a recording, 2 different recordings on my answering machine, saying that, oh, you have this big cocktail party, you know, you owe me this money, surely you're not paying for it. Then her husband left a message after that saying, we do not want anything to do with you anymore. So I said, fine, if that's what this is about. So I went and got a restraining order on her, a temporary restraining order, because she was walking past me and saying, oh, there's the girl having the big cocktail Christmas party. And I mean, and it was just ridiculous. It was like all I wanted to do was continue paying her.
Just a minute. Give me the best reason you have for not paying her.
The best reason is I got fired from the Hyatt Hotel, and where am I going to get the money to pay her now?
Did you get fired because of her?
I believe I did.
No. Well, then, if you believe you did, you got fired because of her, why don't you tell me how?
Because she left a message on my machine saying to me, and it was like on a Friday, and she said, if you don't pay me the money that you owe me, I am going to the Hyatt Hotel and I'm going to tell them that you owe me this money.
Okay.
Judge Judy will continue in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Here we go. A, your countersuit is dismissed. It's nonsense. You don't like the way somebody is talking to you. This is not nuisance, harassment, or anything else. It's somebody who's trying to give you some advice, even though you didn't ask for it. You're a big girl. If you don't like the advice, you don't listen to it and tell her, I don't want to listen to your advice. Don't talk to me anymore. That's not nuisance. That's not harassment. And certainly the only pain and suffering that I see in this case is from these 2 people that lent you money. Now, you got some heck of a nerve to give her $15 Christmas time on a $3,000 debt, $3,000, and then go out and have a party in your house. Big party, little party. You went out and bought invitations. You went out and mailed the invitations. You had a party. You served liquor. You served food. You had to spend at least $100. Can't do a party for less. Right, Bert?
Not doing
No. No. Can't do a party for less. How dare you have a Christmas party when you still owe her $3,000? You got some heck of a nerve. I mean, if you're a big girl and you don't want somebody to act like your mother, start growing up. Judgment in this case is for the plaintiff in the amount of $3,025.
Parties are excused. You may step out.
Judge Judy will continue in a moment.
All parties on Mayhew versus Mayhew. Step forward, please.
28-year-old contractor Sean Mayhew is suing his ex-wife, 21-year-old Amber Mayhew, for back child support for their 3-year-old daughter. Amber is countersuing for utilities.
Order. All rise. Yeah, this is case number 645 on the calendar in the matter of Mayhew versus Mayhew. Parties have been sworn in, Judge. You may be seated. Have a seat, please.
Mr. Mayhew, you and the defendant were married. You are now divorced, and you have custody of the child of the marriage. How old is that child?
3.5.
Boy, girl?
Girl.
Girl. You are suing the defendant for back child support.
Yes, Your Honor.
What does she owe you?
$13.28.
There is a counterclaim here by Ms. Mayhew for some old utility bill.
Correct.
And for some other nonsense. All right, Mr. Mayhew, how long has your daughter been in your custody?
Since she was born, and then when she left in October of 98, 7.
Do you visit with your daughter?
Yes, I do.
Okay. I read in your answer what seemed to be a suggestion that you do owe him money for child support. Is that right?
Yes, the first 2 months. I paid him little bits
$50, $30.
And then you say you've been consistent with your
I
payments
have been
since?
consistent with all of my payments.
Show me.
I have a list here of the time and dates that I paid, and I have a few, I'll let you have it, money order stubs that I have. That's the only receipts. I don't have receipts. I paid him cash the whole year.
Did she pay you cash the whole year, sir?
No, she didn't. I have a breakdown of what she did pay.
And also, here's another one for, I put her in daycare. She's in daycare this month. That's my...
Well, what does your judgment of divorce provide for with regard to payments?
$158 a month.
And it's your testimony that but for the first couple of months you were regular in your payments?
I was supposed to start paying in February. I did not start paying until the middle of March.
No, that's wrong, Your Honor. She didn't start paying until August.
Miss Mayu, you see you have a problem. Let me tell you what your problem is. When somebody sues for back child support, he says you haven't paid. You have some receipts that you did make payments, and he says you did make certain payments. So you are going to have to establish to me that you made these payments, because most people, when they make child support payments, they make payments by check.
I trusted him. I was with him since I was 15 years old. When I left him, I did not have a job. I did not have any direction at all whatsoever. As soon as I did start working full-time, I paid him. She's my daughter. I was an at-home mother with her for 2.5 years. I would not be a loser mom and not pay my child support, period. He is lying. I paid him, period. I have my witness, has been there a few times.
Well, I'll hear your witness.
She also has heard him say that he's going to get me back for anything he can because I messed him up. He wants to, you know, screw me over.
What's your name?
Allison Noah.
Miss Noah, can you recall dates, times, and places where you saw exchanges of cash between the plaintiff and the defendant?
I know for sure on August 3rd, their daughter's birthday, I went to their daughter's birthday party, and I saw her pay him $80 in cash that day.
That's not correct, Your Honor. She never gave me any money on her birthday. Her father, I guess, offered to pay me $60 towards the birthday party, and I refused to take it. I paid for the whole birthday party and everything. She never gave me any cash during that time.
Did you see her?
Yes, I saw
give
her
him
give him
cash?
money. Yes.
At any other time, did you see him accept cash from her, and in what amounts?
One other time in October, my daughter and I were with her and her daughter, and we were in her car taking her daughter to his house. And she gave him, I saw her take cash up to him. I assumed it was $80 because that's how much.
You didn't know how much it was, but you saw him actually accept money. Yes. Do you recall that?
It wasn't cash, it was one of the vouchers that she has up there, one of the receipts, because she was paying at that time.
No, it was cash,
No,
Your Honor.
it's not
It was
here.
cash.
This is not I don't have an October date there. She has 4
And the only reason I don't have
amounts.
receipts is leaving him, divorcing him, I was left with tons of creditors. I did not have a bank account. People were trying to garnish my wages, what little money I was making. I did it out of good faith. I mean, I've known him for, years. I gave him the money,
Mr. Mayu,
yes.
Listen to me, sir. You just testified that you didn't get this payment that she's referring to in October. Is that what you're saying?
Right, I got it in a money order. I got money orders September, October, November, and December, and January. And then my wife served her with the court documents here, and she stopped paying. So I didn't receive anything from this year in February or March.
Miss Mayu, you say that you missed a couple of months
In
initially.
98, the beginning
Just
of
a second,
98.
Just a second.
Okay.
And other than that, you say you were current.
Yes. Every paycheck I got, he was my first person I paid.
Okay.
And the only reason...
Listen to me. Shh, listen to me. I'm getting somewhere.
Okay.
Did you pay him in January of 99?
Yes.
Did you pay him in February of 99?
Yes.
Show me.
I don't have proof of it.
Now I'm going to tell you why. If you're not honest with me right from the get-go, then you always catch yourself. Because you said to me, other than the first couple of months, I've paid him regularly. Then problems started the beginning of this year, the beginning of 99. When were you served with a summons for back child support in the family court? In what month?
I'm really not even sure.
You have a witness?
Yes,
Can
I
you
do.
tell me? Step up, please. You're Miss Mayhew?
Yes.
When did you serve the defendant with the summons for the family court on the issue of back child support?
In February, early February. I don't have the exact date. We filed on February 1st.
You served her that night.
And I served her that night, so February 1st.
Okay. Now, one of the problems that I have, Miss Mayhew, is you did not pay in February at all, and I'm going to tell you why I know that. Because according to the papers that you give me, you show that you have made payments in December, January 19th, 1999, and January 5th, 1999. Okay? So you made 2 payments in January, but clearly you made no payments for February. And did you make any payments thus far in March?
No.
All right. So that clearly there's at least a couple of months that you didn't pay him in September, according to you. Clearly, you made no payments in February, and clearly you made no payments in March.
No.
And you didn't make any payments at the beginning, in September and
No, I did not.
October. Okay. For the first couple of months at least.
The main reason I didn't is he told me he wanted to garnish my wages. That's how it should have been in the beginning. I said, you want money from me? Garnish my wages. Since he's met his new wife, he took, Casey from me. I had her 50% of the time, and after that, it just all went downhill.
Judge Judy will continue in a moment.
Miss Mayhew, who do you think should provide you with a roof over your head? Except you.
Myself, definitely,
Perfect.
I agree.
So you don't get any medals
All
for that.
right,
That's what
all
you're
right.
supposed to do.
You're right.
Real cases, real people. Judge Judy. Sean Mayhew is suing his ex-wife, Amber Mayhew, for back child support. Amber is countersuing for utilities.
All right.
Your Honor?
Yes.
Okay. I filed through the state to petition to garnish her wages because every time she would come over and make a payment, we would get in a fight.
You don't have to necessarily garnish her salary. That can come if she doesn't pay. Clearly she hasn't paid. They're going to garnish her wages now and have the payments made directly through the court. You don't necessarily have to get her employer involved if she was paying directly. She could just make the payments through the court.
Right.
So that there would be a record, so that you both learned a very interesting lesson. And the lesson is you're supposed to have receipts, but you owe them a lot of money, because you owe them a lot of money taking what you say as true, at least part of it.
I swear to God, Your Honor.
No. Listen to me. Taking what you say is true that we found out today. You haven't paid him for a couple of months when you started. You didn't pay him in February, and you didn't pay him in March. The grand total of that is $1,040. Okay, that's a lot of money. Now let's get to your counterclaim.
Where did you think I'm not paying? Where I missed that.
Where? Don't miss it. Did you give him money in November?
I was not ordered to pay him.
I didn't ask you whether you were
no,
ordered.
I did not. No,
That's
I
not
did
my
not.
question.
No, I did not, Your Honor.
Did you give him money in December of '97?
No, I did not.
January of '98?
No, I did not.
February of '98?
No, I did not.
Well, you mean you just told me a moment ago that you didn't have to be ordered by anybody. You know that you have a responsibility. You wouldn't just be a deadbeat mother. And I'm going to tell you, there's a lot of talk about deadbeat fathers when they leave and they don't pay until they're ordered to pay. You said to me that I wasn't under an order to pay. That doesn't mean you don't pay child support. That doesn't mean you don't say...
I completely agree, Your Honor.
So?
I completely agree.
So stop complaining. How many months did you get away with not sending support until you were ordered?
I didn't get away with not
sure
sending
you did.
support.
Did they make a retroactive order in the court? Did they make a retroactive order? Well, they should have. If you were before me, you would have gotten a retroactive order from the time you didn't pay. The courts do not differentiate between fathers and mothers with regard to paying child support. Both parents are responsible to pay child support.
Definitely.
If you walk out of a marriage, that's your prerogative, but you can't walk out of your responsibility to support your child. Now let's get to this ridiculous utility bill that you have here that you counterclaim. You say when I split up, he was to take care of the utility bill, and he did not. You want to tell me about that?
Him and his ex-girlfriend Pam were living there. She moved in a week, 2 after I moved out.
Show me.
I'm being sued for the amount here. And I asked him for the PGE bill. I'm there now.
Well, show me. What dates? I assume there are dates on that.
There might not be, just the amount.
Well, what am I supposed to do with this? You say it was at a time when they were living there and you were not.
Yeah, I had
Show
taken
me.
myself off the lease. That's all I had. It was an old bill. It was from, 97 into 98. It was approximately 3 months worth of PGE, and he was supposed to have put it in his name, and he didn't. And it was my responsibility not turning it off in my name.
Did you pay the utility bills?
Yes, I paid for everything. She had her mail forwarded. I never got a bill for it. I tried to get in contact with her, but the first 2
You never
months,
shut
she
it off
never.
in your name.
Just a second.
I can't shut the electricity bill off when it's in somebody else's name.
In what month did you put the electric bill in your name?
I think it was January.
Okay. So for the months of October, November, and December,
Right.
it was in her name.
Right.
Okay, and you did not pay those bills because you did not get those bills.
Right.
Is that correct?
That is correct.
All right. Well, then you have to pay the electricity bill that you
Okay.
owe, right?
Right. I can understand that to the point. Perfect. Except for that she stuck me with I have to pay for a babysitter because she took off right away on the spur of a moment.
Hey, don't
No.
talk to him. Don't talk to him.
Excuse me, sorry, Your Honor.
So
we don't
I was
offset.
already living check to check.
Listen
so
to me.
And I was living with nothing. Excuse me.
You have to pay for the electric because you use it. You're not going to offset that because of a babysitter. This is your child. Are you happy having your daughter with you?
Oh, yes.
Perfect. And your daughter is fine?
Yes.
Perfect. Let me make some clear suggestions to you folks. I'm giving her credit for the utility bill, which is $350. I am not giving you missed work of $150. That's absolutely ridiculous. You probably caused more missed work for him than I guarantee you this
I
utility
supported
bill.
a two-bedroom apartment all by myself, so taking a
Well,
day
who do you
off
want?
of work was
Who do you-
very intense.
Let me ask Miss Mayhew, who do you think should provide you with a roof over your head, except you?
Myself, definitely,
Perfect.
I agree.
So you don't get any medals
All
for that.
right,
That's what
all
you're
right.
supposed to do.
You're right. Well, I was with him for 5 years, and that was like...
What?
It was a struggle for me. I'm very proud of myself. I'm very honored to say that I take care of a nice two-bedroom apartment and have my own car and pay my own insurance and pay all my own bills, and I'm not depending on anybody, and I still
Well,
paid
that's
him
what
the
you
money.
should be. That's what all people
Definitely,
should be,
but I'm
especially women.
proud. What can I say?
Especially women. They should always make
Yeah.
sure that they can take care of themselves.
Judge Judy will continue. And later today,
And what you said to me, and the answer was, this is between brother and sister.
closed captioning sponsored in part by Real Cases, Real People, Judge Judy. Sean Mayhew is suing his ex-wife, Amber Mayhew, for back child support. Amber is countersuing for utilities.
I'm going to make the following suggestion. That any monies that you give him by certified check, by money order, keep a receipt, or by personal check, which you will get back from him. That you do not accept any cash from her, ever. I'm giving you certain credit for the utility bill of $350. I'm offsetting that against what I believe is a reasonable adjustment of the plaintiff's claim for back child support, and I'm awarding you, sir, $700. That's all.
Thank you, Your Honor. This case basically shows that not all dads are deadbeat dads, and they could be the mother, too.
He said that he was going to do whatever he could to get me back, I screwed him, and, he was going to screw me.
And now the next case.
All parties on Neiman versus Brown. Step forward, please.
29-year-old teacher Kimberly Neiman and her husband, 36-year-old driving instructor Frederick Neiman, are suing Kimberly's father, 59-year-old Kenneth Brown, for a credit card he used to start a business with her brother.
I hate it when families sue each other. So, Miss Neiman, this is your dad. Is that right?
Yes.
And according to your complaint, some time ago, your dad asked to borrow some money from you.
That's correct.
Is that right?
Mm-hmm.
And you gave him a credit card.
Mm-hmm. That's correct.
And bill is way past now $5,000. And you want him to pay the bill. Okay, Mr. Brown?
I did ask to borrow the credit card. It was a bit small business.
I know that you have a daughter. According to your answer, you also have a son.
Yeah,
Was the credit card for your son's use or for your use?
for his use.
So why didn't he ask his sister to borrow the card?
They feud and fight.
What did you say to them when you borrowed the credit card?
I told her that Ken would be using it. His name is the same as mine.
Well, your problem, Mr. Brown, is I read your answer. And what you said to me in the answer was, this is between brother and sister.
Yeah.
You borrowed the credit card. You allowed your son to use it. You say she knew that he was going to use it for a business. Was this business that the two of you were starting together, you and your son?
Yeah, him and I originally, but then we collapsed it.
You have to pay the bill. And then if you feel as if your son owes you money because you had to take on this responsibility, you might have to do what she's doing now. But the card was given to you.
Correct. I just feel that the two of them knew what they were doing, both of them, both sides, that they ought to be dealing with each other.
Well, she knew what she was doing. She was loaning her father her credit card. Is that right?
That's correct.
And according to you, she and her brother didn't get along. Is that right?
Right.
So it's possible that if her brother came to her and said, I'd like to borrow a clean credit card that has a full line of credit, she would have said no. Right?
Possibly.
So you understand, sir, the reason that the credit card was given was because you asked for it. She was relying on you to pay off the bill. She wouldn't have given the credit card to your son. He probably knew that.
Yeah.
Judge Judy will continue in a moment. Are you in a family dispute? Call 1-888-800-JUDY. On the internet, judgejudy.com.
So let me see the balance on the credit card.
This is the newest one. The balance is right.
Have you made any payments at all on these bills?
I have, yeah.
You have?
But they have paid me back. I have other credit cards that they owe me money on.
They advised you almost a year ago that they were removing you as an authorized user of the account. Is that right?
Yeah, we requested that.
You
yeah.
requested that.
Mhm.
Are any of these bills after they were removed as an authorized user of the account?
There hasn't been anything since
There
then.
hasn't been anything after that? Okay. Well, this is well over the $5,000 limit, Mr. Brown. But this is your responsibility. And if you feel as if the business didn't go anywhere that you and your son went to, it failed?
Yeah.
Is that what happened?
Yes.
Well, that's not their fault. Judgment in this case is for the plaintiff in the amount of $5,000. That's all.
Parties are excused. You may step out.
Judge Judy will continue in a moment. And on the next...
All parties on Nocera versus Clark. Step forward, please.
60-year-old Sal Nocera says neighbor 22-year-old James Clark damaged his front door after Sal parked in his space.
All rise. Shh. Yeah, this is case number 685 on the calendar in the matter of Nocera versus Clark. Parties have been sworn in, Judge. You may be seated. Ladies, have seats, please.
How long have the two of you been neighbors?
Since December.
Of 1990?
8, ma'am.
And how long have you been living on that property, sir?
I've been in my home for 19 years.
So you just moved in?
Yes, ma'am.
Evidently, there's some major parking problem here. Is that right?
Yes, that's correct.
Now, is there a garage where the two of you park your car?
No, we have assigned spots. They are small. And
But
somewhat,
outdoor spots?
yes,
Okay, and your spot is next to Mr. Clark's.
one of my spots. He's actually got 3 spots.
Good for him. He's been there 19 times as long as you have, so now he has 3 spots.
Right.
But one of his spots is next to your spot.
Correct.
And I gather that from the time Mr. Clark moved in, there has been an ongoing problem. Is that right?
Yes, it's very difficult to park in the back. I don't have much problem as I have a compact car, an 87 Honda, and the Clarks have a pickup truck, somewhat large, but... it's a Ranger. It's a small truck. It's not a big truck.
It's a truck.
Right.
It's bigger than his car.
Not really, Your Honor. It's a light-duty truck. Doesn't have a standard cab. It's not very big. It doesn't take up a lot of parking spot. I mean.
Okay, but you've had ongoing problems with each other about this spot, about hanging over a little bit on his side and hanging over a little bit on your side. So this problem started. You got angry one day at him.
Correct.
I'm not going to go into the whole history of it. He says you came banging at his door.
Correct.
And you damaged the door. So, what brought you to his door?
Well, the fact that he parked in my parking spot intentionally, just to be snippy, just to instigate an incident. So I got mad at it. So I parked off street and I went up to his door and I started banging on his door. Now, when I banged on his door, I noticed that it was loose and damaged up top, so I began to bang on the bottom. So, you know, I'm banging, I'm telling him to come out, and, you know, so he can move his car. Now, before I went up, I noticed there was a letter hanging on his window saying, I have video footage of my car. If there's any damage, I will take you to court, as if I was going to do something to his car, which I wasn't. I just wanted him to move it. And that's what I was asking him to do. The whole time I'm yelling up to his window, please move your car, please move your car. Now, he mentions in his letter that I made a homophobic remark to him, which I did, and I apologized to him for that. I had no right to say that to him. But, you know, but other than that, as far as the damage to his door, it never happened. And I have a witness, my wife, went up to his house. He was having interior work done, and he had invited her to his house. This was in December when we were on okay terms. And she noticed, and she can testify that his door was already, and it's rusted up top, and he already had damage done to his door. Because when I spoke to the detective...
Don't tell me what the detective said.
Okay.
Now, Mr. Nacera, he says, and you seem to indicate as well, that just prior to that, he had parked in your space, or a little bit over your space. You went up to tell him to move his car, or you called and told him to move his car, and he was in the shower. Is that right?
That's correct. That was that same day.
The same day. And your wife was at home?
Yes, Your Honor.
You drive?
No, I don't.
And you said, wait until I get out of the shower.
Right. Actually, I knew the car was not parked in his spot. When I had went out there after the shower, a quarter of an inch on the white line. On the white line. The white line's about this thick. My tires were a quarter of an inch on the white line, not in his parking spot.
Does that sound familiar to you, that you had a complaint that day?
Pretty much. That is, as I say, it is very difficult to get into those spots. Often the clocks will park on the white line or in the white line on the front and slightly over the white line in the back. That makes it impossible.
There's bars in the way. There's no way I can...
Now, Mr. Nacera, according to Mr. Clark, sir, there was a time when you were friendly with his wife.
Yes, sure.
Until when?
Well, since December, there were incidences of where the car was parked over the line, either the front or the back. And Mr. Clark chooses to leave his tailgate down, which adds about 1.5 feet to the car, his truck. It makes it very difficult to get in, even with my Honda Civic. On that day that he says he's mistaken, I was in my spot, not over the line. I mean, I wouldn't purposely. I have pictures, Your Honor. I have a videotape.
And you'll actually see on the pictures that the door is actually ripped out.
Just a second, I haven't seen anything.
I don't know how banging caused that.
I haven't seen anything. It depends upon how hard you bang, sir.
Let's see. This is the wall inside, Your Honor, the damage that was done to inside my home.
How did he cause damage inside as a result of the banging?
Yes, he started off banging pretty hard. Somewhere about 10 minutes into this incident, he was pounding on the door, pounding on my window, ringing the doorbell.
Is that when he made his homophobic remark?
Yes, he was quite outraged, and he was saying pretty bad stuff. I don't know if I can repeat it here. There was a lot of F words, but he was very, very angry. And I was not about to open the door. In fact, I was on the 911 call, having the police come to try to work something out here, and the operator, in fact, heard the commotion and advised me not to...
Does the videotape have any part of this banging on the door?
Yes, it sure does.
May I see it, please?
On February the 15th, at somewhere between 11:30, 12 o'clock on that night, when he vandalized my door, you'll see a few seconds of it because it's going to be very dark, and you may see...
He never opened the door.
You begin to see the...
That's...
He came up about 12 o'clock last night. He was banging on the door and banging on the door and banging on the door and ringing the doorbell. I mean, he was just livid. This is the second incident of him pounding. Which I
want to listen.
Can you answer the door, please? I'm very violent.
I think
it's the downstairs neighbor in 103. This is the second time. The last time he smashed my security door and caused damage to the wall inside. And now he's wanting me to come out and talk to him. I do not.
I think that is basically it.
And the second time I actually responded to that second time when I came to his door, it's because he sent me this letter in the mail. And at the bottom he puts, P.S. You are asked to respond to this letter in the normal time allowed. I don't get letters all the time, but I figured, okay, maybe he calmed down and maybe he wants to speak to the incident. So I originally sent my wife up there to speak to him because I figured maybe he doesn't want to talk to me. And so he shuts the door on my wife, and then I thought, well, maybe he just wants to deal with me because it's
No,
between me
you
and
didn't.
her.
You got angry that he shut the door on your wife. Mr. Clark.
No, it wasn't because of that, Your Honor. It wasn't because I thought maybe he wants to speak to me. So when I went up, I even asked him, can you, you see it on the tape, can you please open the door? He claims it was banging. I call it knocking, but I mean, I probably should have caused an earthquake, according to him.
Judge Judy continues in a moment.
I said I touched his door. His door? Okay.
You
I
didn't
banged
touch
on
his door.
And later today,
You also say that you want to pay the money back,
Verbally,
as opposed to what?
written contract.
You go to law school in between you driving a limousine?
real cases, real people. Judge Judy. Sal knows Sarah wants his neighbor, James Clark, to pay for his damaged front door. James says Sal parked in his space, but he didn't damage the door.
Your Honor, I have tried also mediation through the court. Mr. Clark refused. I have that here. I have the police officer's report, the detective's report. I have estimates of the work.
Let me see. When did this incident occur? February of ¡99?
Yes, that would be the 15th. The second one was, I think, the 22nd, as indicated on the videotape.
I have to read something, Mr. Nacera. All right. The police officer noticed the following and made note of the following in his police report. He took a picture of the damage to the screen door. He also noted that the screen was pulled out from the frame about 6 inches and the securing welds had been broken. I checked the door frame and noticed 2 stress cracks about 8 inches long in the upper right-hand corner of the door frame. The plaintiff advised me that the cracks were not there before Clark's knocking and the banging incident. We're not talking about rust here to the door, sir. We're talking about a door being knocked off the welds, and we're talking about stress cracks. Now, do you have an estimate?
Yes, there are 2 estimates from 2 different places on the replacement of the security door. The other estimate is from the painter who painted. I saved 2.5 years to have my unit painted. And may I also, Judge, note that Mr. Clark did not apologize to me. However, he did say to the police officer that he did call me faggot.
I tried to apologize to him the second time I came up to his door, and he wouldn't answer it. He put in the letter that he wanted me to respond to it, and when I went up there, I told him that I apologized for making the homophobic remarks. That was it.
Well,
I didn't apologize for damage.
You can understand, sir, and I read what the remarks were, and they were pretty egregious. You could understand why he would not open the door if you're screaming that to him through his door.
That was the first time.
I'm talking about the first time. The first time is the time that I understand that this damage was done to the property. Is that right?
Yes, that's correct.
Well, fine. So, would you please indicate to me exactly what it cost to have this door repaired as well as...
Yes, the door cannot be repaired.
So you have to get a new door?
Yes, ma'am. It
And
has
how
to
much
be
is
installed.
What is the cost of the door?
According to, I have 2. One is from a local place, $250 plus a $50 delivery charge. The other is from Home Depot, comes to $272.96.
And what about the replastering of the...
That was $70. It's indicated on...
Okay.
How could I have caused damage to his wall?
Mr. Clark, let me tell you something. When you lose your temper, which you clearly did on that evening, you lost your temper, whatever the consequences are, it's going to be very difficult for you to establish to me, since he has testified that this was not there before. Is that right?
That's correct.
The fact that you say that it was an old door and that it was rusted on top, that has absolutely no consequence. If
But
it
my
is-
wife saw that the door was busted when she went up there. I mean, way before this incident happened, Your Honor. She saw the door. She saw his apartment complex. She saw it was being worked on by interior decorators.
Did you check the welding on the door when you went up there?
No, I didn't, Your Honor.
She didn't check the welding on the door. This is an old door.
She's
not
an
saying it's a
expert.
new door.
She can see that the door is broken, it's loose up top. She doesn't have to see exact all the
I want to
rivets.
tell you something. If your wife was to stand there and tell me that she noticed when she went up there on a social visit that the welding that held the door in place was broken, I wouldn't believe her, and I wouldn't even ask her
But
that
it was
question.
already broken, so when I went to bang on the door, of course it's going to bang. It's going to get even more loose. Your Honor.
Oh, then you're responsible.
I'm not responsible.
No, you are responsible. If
His
it's-
door was
Listen,
already damaged.
Mr.
How
Clark,
could I
you're
have
not
made
paying-
damage to something that's already damaged?
You're not paying attention, sir. Did you hear what you just said? You just said if the door was already damaged, and because I banged on it, it was damaged further. I'm not
No, 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 no,
responsible.
no. I
And
said-
that's exactly what you said to
I
me.
said I touched his door. His
Touched
door.
his door?
Okay.
You
I
didn't
banged
touch
on
his door.
His door was already damaged. I mean, how can I not knock on it and for it to not get loose? That's
Sure.
just not physically possible.
Mr.
His door
Clark.
was already broken, so I'm banging on it. It's already broken, so I'm not gonna. I mean, how could I have broken it?
Judgment for the plaintiff in the amount of $340. Thank you.
Parties are excused. You may step out.
I've been there 19 years. It's a nice small complex. We're sort of very tightly knit. I would like the Clarks to fit in if we can only work out the parking situation.
I can put it behind me, but yeah, I mean, I'm not going to talk to the guy as far as I'm concerned. He's just a neighbor.
And now the next case.
All parties on Black versus Hamilton. Step forward, please.
35-year-old limousine company owner Dolores Black is suing former driver David Hamilton for a loan. David is countersuing for the cost of Armani suits he used for uniforms.
Ms. Black, you own a limousine company?
That's correct.
And according to your complaint, the defendant was an employee of yours for some time. How long?
Off and on for a few years.
As a driver?
That's correct.
You loaned him some money, $2,000. He
I
had some
did.
financial difficulties. He paid you back $500, according to you, after you made some repeated attempts to try to collect the debt, and he still owes you $1,500.
That's correct.
Now, Mr. Hamilton, I read your answer. So your answer says that, well, you had some financial difficulties, and you acknowledge, sir, that you borrowed this money from the plaintiff. So far, is that right?
So far, so good.
You also say that you want to pay the money back, right?
Verbally,
As opposed to what?
written contract.
You go to law school in between you driving a limousine?
Judge Judy continues in a moment.
You say that as part of your job, you were required to look nice.
Expected.
Bought yourself an Armani suit, Brooks Brothers suit, a Canali suit. Then we got white shirts.
Perry Ellis.
Closed captioning, sponsored in part by Real Cases, Real People, Judge Judy. Limousine company owner Dolores Black is suing former driver David Hamilton for a loan. David wants Dolores to pay for his designer uniforms.
Now, was there any time set for the repayment of this loan, Miss Black?
Yes, there was.
What was the time?
By the end of the month.
By the end of the month?
July of '98, that's correct.
Does that sound right to you?
No.
So you disagree on that, but it's not particularly relevant. Now, what I loved about your response was your counterclaim. You say that as part of your job, you were required to look nice,
Expected.
and that there was an agreement that the plaintiff would reimburse you 50% for your employee uniforms.
That's true.
Is that correct?
To a certain amount, that is correct.
Did he ever furnish you with bills for his uniforms?
No, he did not. And in fact, the employment contract states up to $150, which he signed, and Lonnie, an employee of the company, is the witness to that.
So here we go, and this is the best part. This is what your countersuit is. By the way, you do drive a limousine, which means you're supposed to be in a dark suit, right?
Correct.
Right. Nice black suit, and a white shirt, and a tie. Any color that you like, as long as it's conservative and it doesn't have a picture of Pluto on the front, right?
It depends who you're driving that week.
Bought yourself an Armani suit
Yes, ma'am.
for $1,200? Got good taste. Brooks Brothers suit, $700. This guy's got quite a sense of humor. A Canali suit for $700. How much money did you earn?
Average was probably $8 an hour. Gratuities could exceed $10 an hour on top of that.
So the grand total of $18 an hour, that doesn't require an Armani suit for $1,200. Then we got white shirts. 10 shirts you bought at $40 a shirt.
Perry Ellis.
Love it. Now, this one would really send my husband into a tailspin. You know, he likes those ties, 3 for $10 that you buy, you know. 6 ties at $45 a piece, $270. And here we go. This is almost my favorite. 2 pairs of shoes at $210 a pair. You don't even walk around as a limousine driver.
Judge Judy continues in a moment. Want justice? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Your lawsuit's the most ridiculous thing I ever saw. I mean, I think you're probably almost embarrassed when you had to sign it. Now, why didn't you pay it back at $1,500?
Financial difficulties.
How'd you pay for your Armani suit?
You gotta look nice.
How did you pay for your Armani suit?
Paid for it in full.
How?
Cash or check.
I can't deal with him. Judgment for the plaintiff in the amount of $1,500. That's
Parties
all.
are excused. You may step out.
Judge Judy continues in a moment.
All parties on Fleming versus Bradburn. Step forward, please.
Bar owner Robert Fleming is suing his former bartender, 24-year-old Brandy Bradburn, for not repaying a loan. Brandy is countersuing for her last paycheck.
Order. All rise. Judge, this is case number 605 on the calendar in the matter of Fleming versus Bradburn.
Thank you.
Parties have been sworn in, Judge. You may be seated. Folks, have seats, please.
Mr. Fleming, I've read your complaint. It indicates that the defendant was an employee of yours in your bar.
That's correct, Your Honor.
And she was there for how long?
About 10 months.
What kind of work did she do?
She was a bartender.
According to you, you made a loan to her of some money.
That's correct.
And she didn't repay that loan.
Not yet, no.
What was the money for?
Well, it was to pay off a speeding fine which had gone to a warrant. It was for minor repairs to her car, which she couldn't get insurance on. It needed smogging, and she wanted to pay the licensing for it too.
And how did the loan come about?
Well, one evening she was closing up after the day's trading, and I noticed she was crying. She was pretty upset, and I assumed that one of the customers or something had happened to upset her. When I inquired as to what was wrong, she was a bit reluctant to tell me at the start, but finally I said, look, leave the money alone, because if you're not counting it properly, she couldn't concentrate, and sit down and tell me what the problem is. Finally she did, and she said that this speeding fine had gone to a warrant. She was concerned, very worried, that she was going to be arrested, etc., etc. She had an estimate for the repairs and approximate for everything, and it came to about $650. So I said, look, I'll lend you the money. Don't worry about it anymore. Concentrate on your job. You're no good to me if you can't, if you can't concentrate. And we'll get this matter sorted out. You can pay me monthly. She said, Bob, if you'll lend me the money, I'll pay you weekly. I said, fine, not a problem. I paid the speeding fine the very next day, and then later, it was 2 days later or something, I gave her the money for the repairs, for the smog, for the insurance, and the licensing of the vehicle.
Did you personally pay the speeding ticket?
Yes, I did.
And how did you go about doing that?
On a credit card over the telephone.
Had she given you the ticket?
No, she gave me the details, and I called the Riverside Police Station. They had it on file, of course.
When you say she gave you the information, how did she give you the information which enabled you to call the Riverside Police?
She gave me her name, date of birth, license number of the vehicle, the date that the booking occurred.
Okay. You clearly acknowledge that he paid this ticket.
Yes, ma'am.
Let's start with the ticket. Tell me your version of the events about the ticket.
I did get the slip. I got it in the mail, and I took it to work with me that day. So it wasn't at night when I was counting my money out, and I was upset about it, but I wasn't hysterical. And I did talk to Bob about it. We were friends at one point, and I did talk to him about it, and he did tell me not to worry about it. And I had left the slip there that I'd gotten in the mail. The next day when I came in, Bob handed it to me, and he said, "I've paid this for you." I told him that I would have to pay him back, and he told me not to worry about it. And then we went through this forever about me asking to pay it back and he telling me not to worry about it.
Let's get to the other money that you borrowed from him. What'd you borrow that for?
Ma'am, I did not. Bob had given me a check one time for $1,500 that I ripped and promptly gave back to him.
Smogging your car, insurance on your car, license plates for your car. He didn't pay for any of that for you?
No, he didn't.
You have any proof, sir, that you gave her money other than paying this ticket?
Yeah, Mr. McCarthy was there when I gave it to her. It was in the morning.
Is this your partner?
Yes.
Step up, sir. Mr. McCarthy,
Yes, ma'am.
were you present when he gave her the other $400?
Yes, ma'am.
Did he give it to her in check or cash?
Cash.
You saw her accept it in her hand.
That's correct.
Bob never, ever, ever, at any given point, ever gave me cash in my hand. Ever. And about the loan that he says it's a loan, Bob pulled me aside numerous times. I mean, we have this whole sexual harassment thing going on. I mean,
You're going to tell me about your counterclaim in a minute. Right now I'm talking about his lawsuit, which I find a couple of things suspect about your answer. Let me read you a few things from your answer.
Okay.
First of all, you just told me that this was a gift. He said to you, don't worry about paying me back, don't worry about anything else.
Right.
But in your answer, which is your sworn statement, you say, Bob told me that if I did his books at work, he would pay me $50 a week in cash and deduct $50 a week from the ticket he paid for me.
Right, Your Honor, but in my defense, I was after him all the time. My mother even offered to pay that money to him. I offered to pay it. Finally, he said, if it really means that much to you, you can help me out doing my books, and I'll take $50 off and pay you $50.
Good. So then there was an agreement that you would do his books and he would deduct $50 a week.
Right.
How long did you do his books?
Approximately a month and a half.
Did you do your books?
Yeah, she was helping with the paperwork. Yeah.
About how long?
Like she said, about a month and a half.
Okay, so that's 6 weeks. And did you pay
6
her?
weeks.
Did you pay her for doing that, or did you actually deduct the $50 a week?
No, not to my recollection, I didn't.
So 6 weeks, $50 is
$300.
okay. So that we're clear. I believe that he gave you this other money, and including the parking ticket, you owe him $650. I'm deducting the $300 that you should have got for doing the books, because you should get credit for that. That was your agreement. That leaves $350 left. Now let's get to your counterclaim. Ms. Bradburn, say in your counterclaim that he refused to give you your last paycheck.
Correct.
Tell me about it.
Okay, the night that I left work, I'd left really upset and I'd quit and I'd walked out. 2 days later, I'd called him and asked him if I could pick up my check. He was at the bar. He told me, yeah, fine, whatever. It was a real short conversation. So I went down there that evening with Rich, who was my boyfriend at the time. I went down there that evening to pick up my check. The bartender that was working told me that my check was not there. I asked her if she would get Bob on the phone. She got Bob on the phone. I talked to him. By the time I got off the phone with him, I was in tears. He called me all sorts of things, told me I wasn't getting the money.
How much money did he owe you at that point?
Approximately $300 is the minimum I should have got for the time I'd worked.
How many days' pay was that?
A week and a half.
When she left, was there money outstanding?
She had a paycheck to pick up. Yes, there was.
How much?
I think it was, from memory, I think it was $160. That's all.
Did she pick it up?
No, she didn't. I haven't seen her since the time she left. This is the first time I've laid eyes on her. And I haven't spoken to her in the meantime. I tried on several occasions to contact her. Her telephone had been disconnected. I talked with friends of hers who said that she had moved back home with her parents into some house that they just recently rented. Nobody knew where it was. I finished up calling her grandmother on 3 occasions and left messages there.
What were you calling her for?
To find out what to do with her paycheck, where to send it to. I had no address, I had nothing.
Your Honor.
Yes.
Your Honor, that's all a crock of... If he had my grandmother's number, he obviously had my mother's number. He never once tried to call them.
Judge Judy will continue in a moment.
I, quite frankly, Mr. Fleming, don't think that somebody is in business like you are as Santa Claus.
And later today,
Everybody has one life to live, unless you think you're going to come back as an Eskimo pie. Right? You have one life to live.
real cases, real people. Judge Judy. Bar owner Robert Fleming claims former bartender Brandy Bradburn owes him for a loan. Brandy says Robert owes her for her last paycheck.
Mr. Fleming, let me tell you something. You know, sometimes a little bit of truth on this side and a little bit of truth on this side, sir. I don't know of an employer who was acting reasonably that would make as many phone calls and contacts as you just told me you did to try to give her $160. Maybe my boss would do that if I moved. No, he wouldn't. But I don't know of any normal person who would do that ran a business establishment. Now, if you told me that you called her to find out whether you were going to get your money back, that I could understand.
I didn't call her for that purpose.
Why not?
I wrote it off, to be honest with you. I thought, well, that's the end of that.
You see, my
I'll never
problem
see
is,
my
let me
money.
tell you what doesn't make sense, Mr. Fleming. What doesn't make sense is you're prepared to write off the money that she owes you,
Right?
but you're not prepared to write off money that you owe her.
Well, it was her...
Doesn't make sense to
it
me.
was her wages.
Does that make sense to you?
Not at all.
One is, you say it's her wages.
She
On the
did.
shh, Mr. Fleming. Look at your partner over there. He's got it. You see, if somebody owed me money and walked out and quit in a huff over whatever reason, right, I would say I'm going to get stiffed from the money she borrowed from me. What you're saying is you owed her at most $160. So if I were a person, I would use my math and I would say to myself, I'm still in the hole $70, right? But at least I'm going to write off her pay for what she owes me. Because I, quite frankly, Mr. Fleming, don't think that somebody is in business like you are as Santa Claus.
Your Honor, can I say something?
Sure, step up. Who are you?
I'm Brandy's mother.
Go ahead.
I know for a fact that she did not borrow $400 from this man. We knew that there was a ticket. She'd gotten the notice. She'd taken it to work. She'd left it there. She came back the next day. It was paid. I went up to this gentleman.
Just a second. You don't know any of that. You don't know any of that. That's what your daughter told you.
That's what I told her.
Shh. That's what your daughter told you. What are you looking at me like that for? What am I saying to you that you don't understand? What I'm saying to you is you don't know that. You know what your daughter told me. She's already told me the story. The fact that she repeated the story to you doesn't make it true.
Your Honor.
Why are you looking so confused? Are you confused about what I said?
Well, it's very simple. I know for a fact that she didn't take the money.
How do
I
you
know my
that?
daughter.
Just as, because you know your daughter. Sit
Period.
down.
I
Sit
know
down.
my daughter.
Sit down. No, all right. $650 less $300, which you should have gotten for taking care of his books, leaves $350. Now, since neither one of you can tell me exactly how much your last paycheck was, because you don't have a clue, you have.
I can give you the last 3 paychecks prior to it, Your Honor.
Fine, what were they?
Strike an average, and I've also...
Good.
One was for 160. One was for 110.
Mm-hmm.
One was for 177.50.
Mm-hmm.
And the other one was 205. And part of that...
And that's a week, is that right?
Right.
That's right.
That's a week.
That's
so
$5
all of a
an
sudden,
hour.
so just a second. So all of a sudden you made twice as much?
No. I didn't
just
say
told-
that. I didn't say that. I was just adding in the fact that he said he was going to pay me on top of that. So I just added the $50 for that week.
I'm just looking at your last 4 paychecks, madam.
Understood.
They didn't get to $300. Judgment in this case is for the plaintiff in the amount of $200. I'm averaging the last paycheck at $150. Thank you very much. That's all.
As excused, you may step out.
I think he's a big liar. He always has been, and a cheat and a thief.
Don't lend money out to people. They only end up screwing you.
He's asking me to marry him and have his children and dump my boyfriend and change my life and touching me and grabbing me and keeping me and irritating me, so I left.
There's never been any harassment.
And now the next case.
All parties on Redding versus Ullman. Step forward, please.
36-year-old Carlene Redding claims her ex-husband, 41-year-old Thayer Ullman, owes her for a credit card bill. Thayer says that bill was covered in the divorce.
How long are you folks divorced?
It's been approximately 2 years.
Is that correct?
2.5.
Did you have an attorney?
Yes.
Did you have an attorney?
Yes, I did.
This lawsuit, Ms. Redding, says that your former husband caused you to have a credit card bill that you think he should pay for.
Yes.
He says that that was all resolved in the divorce, right?
Yes, ma'am.
Let me see the judgment of divorce while I'm asking you some questions. See it, please.
It's on page 3 of the property. So,
Now, Ms. Redding, what credit card is this?
Citibank Visa.
When were you separated?
Probably 6 months before that.
6 months before the divorce? Is that right?
Yes.
September of '96 is the date of your divorce. On page 2, which is an important part, you directed me to page 3, but on page 2 it says the petitioner and respondent shall each indemnify the other. That means that you'll cover the other for court costs. And it further says that any other debts or obligations incurred in his name, is your name, since the separation are yours, right?
that's right.
That's what it says. So 6 months prior to your divorce would be March of '96. So show me these bills that you have from Citibank Visa that you claim he is responsible for.
This card was run up way before she even left anyway, because it was already maxed out.
I just want to see, sir, if there are any charges there after March of 1996. If there weren't any charges on that card that were yours after 1996, then Miss Redding is responsible because she agreed to pay the Citibank card in the divorce.
Judge Judy continues in a moment.
You're the one who's ultimately going to suffer. You put a period to the end of this relationship, you got a divorce, move on with it.
Real cases, real people. Judge Judy. Carlene Redding is suing her ex-husband, Thayer Ullman, for a credit card bill.
So, Miss Redding, what I want to see are those charges that were made after March of 1996. All right. This Citibank Visa card you agreed to pay for in the judgment of divorce. You were represented by an attorney.
Yes.
Fine. So this card had a substantial balance on it.
I did not run it up.
Doesn't listen to me. Matt, let me take care of this business my way first. What is Klepper's Corner?
That's a gas station, Your Honor.
Do you use that?
I put probably 4 or 5 charges in the gas. We both did.
I'm talking about after March of '96.
I didn't think there was any charges after.
March of
she had
'96,
left.
I have a Klepper's Corner, $19. Another Klepper's Corner, and that's gas. Is that right?
Yes, ma'am.
For $23. And another, what's Phillips?
It's a gas station, too.
It's a gas station. Well, who fills up there?
Not me. I pay cash.
Do you still live in the same area?
No, I live in Salina, Kansas.
And where do you live?
I live in Fallon, Kansas, which is a small town outside Salina.
But you live in Salina?
Yes.
When did you move there?
Shortly after our divorce.
After your divorce or after your separation?
Separation.
Well, then these are all your bills.
That's right.
Because this is all from Salina, Kansas. All of these gas cards are from Salina, Kansas. And they're not very much to begin with. Let me tell you what they are. You're talking about $100. Period. The rest of the bills are yours, madam. I mean, so what did you bring him here for? Come on, talk to me.
I can't afford to pay this.
Well, but that's not his fault. And the judgment of divorce clearly says that any bills that were incurred after the parties separated are their own individual bills. Now, you understood this, right?
To a certain extent, yeah.
Yeah, but you can't come back 2 years later and say, I just can't afford to pay it, and they want to do a do-over.
Your Honor, can I
What?
say- When we separated, she had the choice of what bill she was going to pay. For 2 years, she has done nothing but harassed me, harassed my family. My daughter has gone to a counselor for over 6 months because of this woman. I don't belong here.
Judge Judy will continue in a moment. Are you in a family dispute? Call 1-888-800-JUDY. On the internet, judgejudy.com.
Miss Redding,
Yes, ma'am.
this marriage is over.
Yes.
You have no children together?
No.
Good. You had a divorce? You had counsel? It's finished. And I'm just going to say to you that everybody has one life to live, unless you think you're going to come back as an Eskimo pie, right? You have one life to live. And if you're going to spend your life on a lot of negative energy, you're the one who's ultimately going to suffer. You put a period to the end of this relationship, you got a divorce, move on with it. These are your responsibilities. You have to take care of them. You got to leave him alone, because if you don't have children together, there is absolutely no reason for you to have any contact with this man or his family. And if you do, one of these days, he's going to file a lawsuit with you civilly for harassment, or he's going to have you arrested criminally for harassment. Do you understand?
Yes, ma'am.
That's going to be very unpleasant. This case is dismissed.
Parties are excused. You may step out.
Judge Judy will continue in a moment.
All parties on Sewell versus Ware. Step forward, please.
40-year-old clerk Carol Sewell is suing former boyfriend, 29-year-old James Ware, for keying her car and ripping a gold chain from her neck. James is countersuing for damage to his car and harassment.
Order. All rise. Yeah, this is case number 674 on the calendar in the matter of Sewell versus Ware. Parties have been sworn in, Judge. You may be seated. Folks, have seats, please.
All right, Miss Sewell, you and the defendant had been involved in some sort of a relationship. He went to jail, according to your complaint. When he got out of jail, he keyed your car. Is that right?
Yes, he did.
Did you see him do it?
I seen him do it the second time. The first time, my sister saw him do it.
Step up, you. What was he in jail for, by the way? What were you in jail for, sir?
She sent me to jail for, well, it wasn't jail. I caught a parole violation. The way the parole system works is all she has to do is make a complaint, and they put me back in prison.
How long were you on parole?
I was on parole for 4 years.
What were you originally incarcerated for?
Involuntary manslaughter.
And during that parole period, she called and registered a complaint about you.
Yes.
Was her complaint domestic violence?
More or less. I have her charges here.
Let me see. And when you went back to jail, how long did you serve, sir?
She did it a couple times. The first time was 6 months, and the second time was 2 years.
You did 6 months, but that wasn't on a parole violation.
Well, yeah, it was on a parole violation that I did a 6-month violation because she said that I had stole her gold chains, and she's done this a couple of times. It's like a fatal attraction that she has for me.
All right. Listen to me. Did you ever witness him keying her car?
Yes, I did. The first
What's
scratch.
your name?
Sandra Masal.
Miss Masal, when was that?
It was the end of October. He came to my house on a Saturday.
October of 98?
98. Came to my house about 8 o'clock on a Saturday morning, knocked on the door. I got up because she was asleep, and I asked who it is. He said, Jamie, and he looked in my window, the top of the door, and I said, just a minute, and I went and woke her up, and I said, Carol, Jamie's out there, and I told you I don't want him on my property anymore. So she gets up, she goes outside, stayed out there about 20 minutes, she came back in, And I was watching out my bedroom window, and he walked over to the car with his key and went right down the side of her car.
Jamie, this lady is telling me the truth. When did you get out of jail?
I got out of jail August 29, 1998.
8/29. So a month later, you're at her house.
No, I live with my fiance.
No. A month later, you went to her house.
No, I didn't.
You mean to tell me she's lying when she says you even came to the house to talk to her?
Very true.
In October?
I haven't been allowed at her house, Your Honor, for
that never
a
stopped
couple
before.
years.
Jamie. You have to be careful, because then I won't believe anything that you tell me. Now, tell me about the gold chains.
Well,
You say you have the receipts for the gold chains. She says you ripped them off her neck.
yes, Your Honor. She's made malicious stories up on several occasions.
Well, I understand that. Your defense is not that it didn't happen. You said they're my chains, and I have the receipts for them.
Yeah, here's the receipt.
All right, so there you go. Let me see the receipt, please.
Sure. I'm unsure of what chain she's talking about.
Just a minute.
Welcome to Auto Bike Brand, your trusted source for the latest and most exciting updates from the motorcycle world. Today, we dive into the timeless cruiser that has defined American touring for decades, the 2025 Harley-Davidson Road King. Known for its iconic presence, unmatched comfort, and heritage styling, the Road King continues to be the motorcycle of choice for riders who crave long-distance freedom with a classic soul. A heritage of power. The 2025 Road King is powered by Harley-Davidson's Milwaukee 8 114 V-twin engine, delivering robust torque and smooth acceleration for highway cruising. With a displacement of 1,868 cubic centimeters, it offers the deep, signature Harley rumble that resonates with tradition. The refined engine tuning not only enhances throttle response, but also ensures cooler running temperatures, making it ideal for extended journeys. Classic styling with modern touches. The Road King's design remains a tribute to Harley's golden era of touring. The large chrome headlamp nacelle, full fenders, and clean lines preserve its classic appeal. For 2025, subtle updates include new color options, improved chrome finishes, and optional blacked-out packages for a more aggressive look. This blend of heritage and customization ensures the bike appeals to both purists and modern riders. Touring comfort at its best. Riders will appreciate the spacious saddle, upright riding position, and roomy floorboards that make long hours in the saddle feel effortless. The bike features hard saddlebags with a one-touch opening mechanism, perfect for stowing gear. Suspension improvements for 2025, including Showa dual-bending valve front forks and adjustable rear shocks, provide a smooth and controlled ride, even on less-than-perfect roads. Technology for the open road. While the Road King keeps its dashboard traditional, 2025 brings discrete tech upgrades like improved LED lighting for better night visibility, a standard USB charging port, and enhanced ABS for safer braking in all conditions. Optional reflex defensive rider systems offer extra safety features, such as traction control and cornering ABS without compromising the bike's classic look. Performance meets practicality. With a 6-speed cruise drive transmission, the Road King offers effortless highway cruising at lower RPMs, reducing vibration and improving fuel economy. Its 6-gallon fuel tank ensures fewer stops, while the robust frame and low center of gravity make the bike stable and confidence-inspiring, even when fully loaded for touring. Why the Road King still rules. In a world filled with high-tech motorcycles, the 2025 Harley-Davidson Road King stands out as a motorcycle that delivers not just transportation, but an experience. It's a machine that connects rider to road, history to the present, and tradition to innovation. Whether it's a weekend escape or a cross-country adventure, the Road King continues to be the true king of the highway.